Okay, good afternoon. So previously we finished types of fraud, right? So as regarding fraudulent misrepresentation. So now we are moving to negligent misrepresentation. Okay. So as the word negligence suggests, so you can see that it means like when you are careless to make a mistake, right? So sometimes when a party make a misrepresentation through carelessness, believing that the statement is true, okay? So if the party did not exercise reasonable care in uncovering or disclosing the fact or use the skill and competence that her or his business profession requires, misrepresentation might constitute negligent one. Okay, so for instance, right? So if you need to if you are a company and you need to buy 100 tons of potato, right? And you need to have a certification, right, of the weight of the that 100 tons of potatoes. So you ask a company to do that, and the operator of a weigh scale certifies that weight of the commodity, right, of the potatoes. However, even though the accuracy of that scale has not been checked for more than 3 years, right? So it means like they negligence, they are careless of what they should, of what is expected, in their profession, right? And in most states, right, those negligence representation is sometimes considered. No, this one is too confusing. Maybe I will let up you guys for that, just in case that you will confuse between fraud and negligent misrepresentation. Okay, so in short, when someone is careless about what is of what of the skill or the competence that his or her business or profession requires, that negligence is actually called negligent misrepresentation. Okay, and the aggrieved party may actually rescind the contract and claim the damages. So in the example above, right, the one that asked the operator to certify for the weight can rescind the contract and actually claim for damages because of the operator's negligent misrepresentation. Okay. So since we have studied several classes already and you get used to the materials, so I will move a little bit faster than the usual pace right at the beginning. So I started slowly for you to get used to the contents and the materials, but now we have studied several classes, so let's move in the normal speed. Okay. Next one, innocent misrepresentation. What does it mean, innocent? Right. So if a person makes a statement that she or he believes to be true, but that actually misrepresents material fact, the person is guilty only of an innocent misrepresentation, not fraud. Right? Fraud, it means that you consciously, right, you intend to deceive them. But this one, that you are actually innocent, quote unquote, right? So when an innocent misrepresentation occurs, the aggrieved party can rescind the contract, but usually cannot seek damages. Right, so difference, right? So for example, if A is selling a piece of land to B, and A say that, it actually 250 square meter, all right? But actually that one is only 115, right? Instead of 50, but it is actually 15 only. And A had no knowledge of that mistake. B rely on the statement right? And contracts to buy that piece of land. So what is the legal consequence in this case? What is the legal consequence in this case? Anyone? Right? So A is the owner of the piece of land, right? So in A's mind, he believes that the area of this one is 250, right? However, the actual one is only 215, okay? And B actually relies on A statement and contracts to buy the land. So in this case, right? And then B actually realized that the actual area is only 115, not 150, 215, not 250. So what can we do? What can we do, everyone? What can we do in this case? Does B have to continue like ratify the contract, or uh, if you were B, what is your what are your options, or what is your option?
If I were B, my option probably seek for my to take back my money because I pay for 250 square land rather than 215 square land. Like,
Okay, yep, agree, right?
So yeah,
Yes.
maybe I talk back, I make a conversation with A and discuss maybe on in the contract, or they keep the calculation, and I ask A to get money equivalent with the money that it's not, what's it, ask A give money back to me. It's just a small amount of money because I buy 250 meters square of land. So after that, I call the some was, I don't know, maybe some officer or something, call them, come over and start to measure my land again and have what's it, official contract of that.
Sure. All right. Thank you. Yep. Right. Phụng, thanks Phụng. So Phụng option, Phụng suggestion would be she will still ratify the contract is still carry on, right? But you will get back the money equivalent to the 300, the 35 that was, innocently misrepresented by by A, right? And then you will get an officer to come over and measure to get an official certification. Is that what you meant? Hello, Phụng, can you hear me?
Yes, ma'am.
Yes. Okay. I just ask you, like, You mean that you will take back the amount of money equivalent to the 35 square meter, right? The difference, right, between
Yeah.
what A said and what the actual area, right? And then you
Yes.
will ask for an official certification from an officer. Okay, thank you.
Yes.
Yep. So that could be an option, or if you really don't want that contract to be performed, you can avoid the contract, right? Because this misrepresentation is material, is very important, right? The area of the piece of land. Okay, so you can have the worst scenario is that you can avoid a contract, uh, and of course you cannot ask for damages because if A can prove that the misrepresentation is innocent. Okay, right. So this is the summary. I believe this one is available in your textbook as well. But if you do not have the textbook yet or have not read the textbook, then it could be useful. Right. So the next one we are discussing is duress, right? What does it mean by this? If you study civil law, a civil code, and if you have read the civil code already, then you want to see these terms many, many times, right? Again, one of the very important element of a contract is that the person must enter into the contract voluntarily, right? Must enter into the contract voluntarily. So if one of the parties or is forced into the contract, right? Uh, the agreement is not voluntary, right? And the use of threats to force a party to enter into a contract is understood as duress. Okay, again, the use of threats to force a party to enter into a contract is referred to as duress, right? Or other type like blackmail or extortion to induce consent to a contract also constitutes duress. So duress is both a defense to the enforcement of contract, right? Sorry, hold on, let me change the slide. Um, So duress is both a defense to the enforcement of contract and the ground for the rescission. Okay, so it can serve both. We discussed the defense to the defense to the enforcement of the contract and before, right? So again, duress, defense to the enforcement of contract, and ground for rescission. On the slide. Okay. So to establish duress, what do you think they must prove to establish duress? What proof do you think that the claimant must provide or the plaintiff must provide? So to establish duress, what proof do you think the claimant or the plaintiff must show? Anybody? What do you think? Okay, so to establish duress, we have to prove that there is a threat to do something that threatening party has no right to do. Okay, so generally, if we have to prove that duress occurs, right, the threatening act must be wrongful or illegal, and it must render the person incapable of exercising free will. Okay, so how if you threat to exercise a legal right, like to sue someone, usually it does not constitute duress. Right. So let's look at an example. Let's look at an example. So, Jay actually accidentally drives into O's car. Right, this is O's car, and at the stoplight, right? And Jay has no insurance, right? Has no automobile insurance. And however, Jay has a substantial asset, right? And at the scene, right, there's an accident, of course, right? Accidentally rub into the car, right? So rub into this car. So at the scene, oh, say that, right? If J agreed not to file a lawsuit against her if she pay him 5,000 US dollar. Okay, so O asked for 5,000 US dollar. And J, of course, refused, right? Initially refused, but then O say that if you don't pay me 5,000 right now, I am going to sue you, and that lawsuit may cost you 25 grand. Okay? And so therefore, J actually finally give O a check, right, for 5,000 to avoid a lawsuit. The next day, right? So let's say this is March 14th, right? The next day, March 15th, J actually stopped the payment on the check. And O later sued to enforce their oral agreement for the money, 5,000 US dollar. So, and J claims this is duress, right? By O asked for 5,000. J said that this is duress, right? And use it as a defense to its enforcement. So in this case, if you were a judge, how would you decide? If you were a judge, how would you decide this case? Or are you clear of the scenario?
I'm not really sure yet. Can you please say it again first?
Yeah, sure, of course, right? So let's see. Okay, there's two cars, right? One is O's car and one is J's car. This is J's car, this is O's car, right? And then J actually drove into, hit O's car at the stoplight, at the traffic light, okay? And J has no insurance, like the car has no insurance, right? However, she has a lot of money. And at the scene, at the accident scene, okay, O say that, O suffer some problem with the car and tells J that I will not file a lawsuit against you if you pay me 5,000 US dollar. Okay, O say that to J, right? And then at first, J refused, right? But then O actually say that, okay, if you do not agree with this 5,000, I will file a lawsuit against you, and that to ask for 25 grand, to ask for 25,000 US dollar. So then J actually agrees to give O a check. This is a check for 5,000 to avoid the lawsuit, right? This is a lawsuit. The next day, right? So on March 14, J actually give O the check. But then on March 15, J stopped the payment. Right? You can just call the bank and say that, the check is voided and is void, and I would like to stop the payment. Okay? Stop the payment of the check, on the check. Okay? And then later on, O actually, so let's say 16, O actually sued J to enforce the oral settlement agreement, right? This is actually the oral, they spoke with each other, right? Oral settlement agreement. And in this case, J actually say that at the beginning, in this one, to ask for 5,000, O actually harass J, right? And say that duress, this is actually duress. And use this as a defense to the enforcement. Right? It means the reason not to enforce, right? We know this already, defense to the enforcement. So in this situation, if you were the judge to this case, O versus J, what would your how would you decide? What would be your decision? What would be your judgment? Anybody, please? Very straightforward. I'm asking about duress, which we have just discussed right before the example. So if you were the judge to this case, what would be your decision? What would be your judgment? Okay. All right. Someone say, "Oh, threat was not a wrongful act, so did not constitute." All right. Can you please explain a little bit, Jolam, why it is not a wrongful act?
I don't know how to explain it thoroughly, but I think that because in this case, Jay was wrong at the first time, and uh, Jay has to pay damages to O anyway.
Mm-hmm. Okay, thank you. Yes, your answer is correct, but anyone could help to elaborate more. Like just imagine if this is an exam, right? You have the right answer, but you have not got the supporting evidence yet, right? Or supporting how can I say statement yet. So anyone could help.
Miss, may I share my opinion?
Yes, of course.
Okay, so in this case, I think that it depends on the money. That is whether the $5,000 is equivalent to the damage of our car or not. If the
Mhm.
money is succeeds the damage, that means I want to get more money than he should be. So
Mhm.
he's were in his bad faith, and if he want to sue Jay to the court, that mean it will be I mean that is his threat is considered as a duress.
Okay, thanks, Ellen. All right, so yep, in on the slide, right? The slide did not point out that, but I just mentioned previously that the threat to exercise a legal right, such as the right to sue someone, usually not constitute duress, right? So in this case, right, because O has the right to sue J, right? Because you bump into my car, right? So the threat to sue does not constitute duress, right? And if you threat to sue a criminal suit, then it would be right. But if the threat of a civil suit, this is civil, right? Just ask for compensation. So this a threat of a civil suit usually is not considered as duress by the court, right? So in this one, is not duress does not exist, all right? But Lynn has a very good point about the 5,001. If whether it is unconscionable, whether it is not, like for example, it is only 200 and you ask for 5,000, that is a different story. But it hit the car, hit the one J's car, hit O's car, so the 5,001 should be reasonable. So again, please remember that, if you threat someone that you will sue that person for a civil suit, then usually it is not considered as duress. Okay. Next one, undue influence, right? Undue influence. What do we mean by undue influence? If you have read the material, could you please share what do we mean by undue influence? Okay, so undue influence actually arises from relationship in which one party can greatly influence another, and therefore overcoming that party's free will, right? And again, right, a party to a contract must has genuine consent, right? If you are influenced by someone else, and therefore to enter into the contract, right? Your as a party to the contract, did not have the genuine consent, right? So the contract entering into under excessive or undue influence lacks voluntary consent, right? And is therefore voidable. There are different things to look at undue influence, right? However, uh, uh, an essential feature of undue influence is that the party being taken advantage of does not exercise free will in entering into a contract, right? It is not enough that a person is elderly or suffers from some physical or mental impairment, right? There must be a clear, convincing evidence that the person did not act out of his or her free will. Okay, there are a lot of cases regarding this. So similarly, right, the existence of fiduciary relationship alone is insufficient to prove undue influence. Okay. So this is when one party actually dominates the other. You can see that in different relationships, like for example, physician and patient, parent and child, husband and wife, or guardian and ward situations. Okay. So let's look at an example to clarify this point. So E is the guardian. Okay, right? So E is the guardian, K is the ward. Maybe this one is new, so yeah, I can write so you can put. So on her behalf, right? So K is a male and A is K is a female and E is a male. Okay. Let's say let's use the name. So is it Eric and Katie, right? So on behalf on her behalf, on Katie's behalf, Eric actually entered into the contract which he benefits financially. So if Katie challenges the contract, I mean, like, say that the contract is not, I cannot be enforced, the court will likely presume that the guardian has taken advantage of his word. And to rebut, right? To rebut this assumption, Eric has to show that he made a full disclosure to Katie and that consideration was present. And he must show that Katie received, if available, independent and competent advice before completing the transaction. So unless the presumption can be rebutted, then the contract will be rescinded. Okay, so this is an example of the presumption of undue influence in some situation. So when the contract enriches the dominant party, in this case, Eric, the guardian, right? Of course, you have a more dominant power than the court. The court will presume that the contract was made under undue influence. So you have to show that Katie was fully disclosed of the contract and also received an independent or competent advice before completing the transaction, right? So there are 4 elements to show in order to prove undue influence. You can see here. Right. Sorry, 2 elements, not 4 elements. The fiduciary or confidential relationship existence and use their influence to persuade the servant party to enter into the contract. This, I just tell you the example. Next one, unconscionability. Unconscionability. What does it mean when we say unconscionability? I mentioned this term previously, but not sure if anyone remember. What does it mean when we say unconscionability? Anyone remember what do we mean by unconscionable contract or unconscionable clauses? I briefly mentioned this.
I don't know, but I see the word contract of acquisitions. And as far as I remember, is a contract that only have advantage for one party. Usually for supply amenity or fuel or something that the other party must only have two options. Agree with that or waive that contract.
Okay, thank you. Thanks for yes. So it's like when one party has much more bargaining power than the other parties, right?
Yes.
Yes. So we did an exercise on that. So unconscionability, right? When we say that or unconscionable contracts or clause, as I mentioned before, right, usually the court does not look at the fairness of the contract, right? For example, that your house is estimated as 10 billion, the market price, right? And then you sell it to me at 8 billion, right? The court does not care, right? In terms of fairness or equity of the contract, right? And because people are assumed to be reasonably intelligent, right? And the court will not come to their aid just because they have made any unwise or any foolish bargain. However, right, in some circumstances, when the bargains are so oppressive that the court have to relieve the innocent party of part or all of the duties, right, and such bargains are deemed to be unconscionable, right, because they are unscrupulous or grossly unfair as to void of conscience, right? From the word itself, if you don't know the word, you can Google it. Okay, so like if your house is estimated at 10 billion, and you sell it to me at 1, so then there might be the problem with the contract or the clauses. So the UCC, the Uniform Commercial Code, right, incorporates the concept of unconscionability in its provision with regard to the sale and lease of goods, right? The contract can be unconscionable on either procedural or substantive grounds, as discussed, we discuss it in the following way, in the following sections. Okay, so let's look at first the procedural unconscionability. Right, for procedural unconscionability and substantive, we look at both things, right? So, for example, like if there is any unintelligible language, right, or any lack of opportunity to read the contract or ask the question about the meaning. So those type of unconscionability typically arises when the person's lack of knowledge or understanding of the contract term deprived him or her of any meaningful choice, right? And procedural unconscionability can also occur when there is such disparity in bargaining power between the two parties, right? That the weaker party's consent is not voluntary. Like it is like what for just previous just pointed out, right? And that one is adhesion contract, right? Which a contract written exclusively by one party and presented to take to the others on the take it or leave it basis, right? Either you agree to that or you don't. You don't have a choice to negotiate, right? And however, not all adhesion contracts are unconscionable. Only those that unreasonably avoid favor the drafter, right? So if you sign a contract with an investor, like let's say Phú Mỹ Hưng, and if that contract is 100% drafted by Phú Mỹ Hưng legal team, right? You cannot negotiate, say, no, oh, I don't like this clause, I don't like this term. You cannot do that at all, right? However, that contract was fine if it is not, right, if it does not reasonably favor the drafter. In this case, it's Phú Mỹ Hưng Corporation, right? So, however, if uh, the contract just give you all of the disadvantages, that you don't think that is reasonable, then of course, then that one is considered as procedural unconscionability. Okay. Substantive unconscionability occurs when what? When contracts or portion of contract are oppressive or overly harsh, right? And they usually could focus on provisions that deprive one party of benefits of agreement or leave that party without any remedy of non-performance by the other. So, for example, if contract clause that give the business entity free access to court, but require the other party to arbitrate, right? Any dispute with the firm, those kind of terms may be considered as unconscionable. Okay. So let me draw it for you so it's easier for you to understand. Let's look at like this. So this is unconscionable contract or clause, right? So this is a contract clause that is void for reasons of public policy, right? You can have either procedural unconscionability, right? Procedural or substantive. Okay, substantive. Substantive. So in procedural, right, this one unconscionability. This one occurs if a contract enter into or term becomes part of the contract because of the party lack of knowledge or understanding of the contract or the term. Right? In the substantive one, like the name suggests, this exists when a contract or one of these terms is oppressive or overly harsh. Okay, so in this case, what factors that the court can consider? Right. Factors court consider, right? Okay. So, for example, in this one, they're going to consider like if the language Right? They're gonna consider, like for example, if the print if the print is or consider like language, they could consider opportunity, so these are something that the factors, some factors that the court may consider. But in this case, like we can say, for example, does the provision of the contract actually deprives one party of the benefit of the agreement? Or it could be like no remedy, leave one party with no remedy for non-performance by the other party. Okay, so this one is I just put in the chart so it is easier for you to remember. Okay, let's move on. For Vietnamese, the legal defense. Right, please read from Article 123 to 129 of the Civil Code 2015. Okay, and then you can make you can compare and contrast between the two legal systems. Right, so if you have any question, you can just let me know. Next one, form of contract. Right, so we looked at first under the U.S. law, statute of frauds. Right, consequence. There's some contracts will be in writing and some exceptions. What do we mean by statute of fraud? Right. What do we mean by statute of fraud? So, you know, every state in the US has a statute saying that what types of contracts must be in writing, right? Because we studied before, not all the contracts are required to be in writing, only some, okay? So, and such statute is known as the statute of frauds, okay? And the origin of this statute can be traced back to early English law. Okay, so there are some consequences, right? So for the contract not to be in writing if it is required to, it is unenforceable if it is executory, and the contract voluntarily executed by parties will not be rescinded. Okay, will not be rescinded. So what some types of contract have to be in writing, as you can see here. Involving trust of land, right? Cannot possibly be performed within a year. Collateral contracts, right? Promises made in consideration of marriage or sale of goods more than 500, and the real estate agent's contract. So let's say, for example, let's look at an example, right? To illustrate this point. So Sky, right, contracts orally to sell his piece of land in Fumihung to uh, Benny. Okay, so later on, if Sky decides not to sell, can Benny enforce the contract? Again, Sky contracts orally to sell his piece of land here. It's in Fumihung, right? So on March, let's say, uh, March 1st, right? Sky say that to Benny, piece of land. And then on March 3rd, Sky say that no, I don't want to sell that piece of land to you anymore. So generally, the question is, can Benny enforce the contract?
I think that Benny cannot enforce this contract because this contract is unenforceable.
Okay, why it is not enforceable, Yola?
Because this was made orally, while this contract, in order to be enforceable, must be made in writing.
Okay, thank you. All right, anyone else? What do you guys think? Anyone else? Do you agree or disagree with Kiran?
I think I also agree with her too.
Okay, yep, right. So in this case, right, Benny cannot enforce the contract, right, because the statute of fraud requires written evidence of contract for transfer or the interest of land, right, or in real property, right, involve interest of land as number one, you can see, right. So land is a real property and includes all the physical objects that are permanently attached to the soil, like building, fences, tree, and the soil itself, right? So in this case, because the statute of fraud requires written evidence, therefore, and between Sky and Benny does not have any, do not have any. So therefore, Benny cannot enforce the contract if later Sky decide not to sell. Right? This is generally right. If there are some other facts given, then of course the answer may be changed a little bit, but generally and under most circumstances. Okay, so next one. That is an example. So there are actually a lot, right? However, everything has exceptions, right? The exception here is actually, we will discuss is parole evidence rule. Wait, parole evidence rule. What do we mean by that? What do we mean by that? So the parole evidence rule, under the parole evidence rule, if a court finds that, right, written contract represents the complete and final statement of the parties' agreement, then it will not allow either party to present parole evidence, right? So what is parole evidence? Parole evidence is the testimony or other evidence of communication between the party that is not contained in the contract, right? And for example, the he said, she said, right? So, and a party normally cannot present evidence of the parties' prior negotiations, prior agreements, or any, contemporaneous, something happened at the same time, oral agreements, if that evidence contradicts or varies the terms of the written contracts. Right? So this one you can read more at section 213 of the Restatement Second of Contracts. Okay. So let's look at the an example to understand the what do we mean by that, right? So company ticket, right? They sends Gary, right, an offer to sell a ticket to let's say Mỹ Tâm live shop, okay? And the prices and seat locations are indicated in the diagram in the brochure, right? Actually, send a brochure, and then you have like the seat. Right? There are some stage, right, etc. Right? They have the prices and seat locations are indicated in the diagrams in the brochure that accompanies the offer, right? And Gary responds, listing the seat, right, preference. right? And the tickets company later on sent Gary the tickets along with a different diagram showing the seat location. Right? So this is a ticket, right? And then later on, I show another diagram and a document saying that this is the entire agreement of the parties. And then Gary actually signed this one and sent and returns the documents, right? And then Gary goes to the live show and discovers that the seat is not where he expected based on the brochure, right? So in the ticket, they gonna send out another brochure, another seat diagram, right? Seat diagram together with the ticket. So under the parallel evidence rule, can Gary introduce this brochure? No, this is document number one. This is document number two, right? So this is the ticket. So the question is, if in front of the court, right? Can Gary introduce document number one, right? As as evidence supporting the agreement between Ticket INC and Gary. Right, so this one is I give this example, right, to illustrate first on the parallel evidence rule. Before we discuss the exception. Must know what it is, right? So evidence. This is an example to illustrate the parallel evidence rule. So again, the question is, if, right, Gary needs to go to the court, can Gary show, right, or introduce document number one as an agreement between the parties? What do you guys think? Applying the parallel evidence rule that I have just stated. So can Gary introduce document 1?
Just can I share my opinion?
Yes, please.
I think that Gary cannot use document number 1
Okay, why not?
evidence because it was not included in the final contract between the ticket company and Gary.
Okay, hold on 1 second. Give me a second. It was not introduced. Okay, but it is actually what can I say? It is actually that is the document that Gary got at the first place. Why can it be used?
Because it was not concluded in the final contract with them. Oh, sorry, the final contract between them.
Okay, it was not concluded in the file. Okay, thank you. Who is that? Sorry. Is it
It's Chao Long, miss.
Chao Lang. Okay, sorry. Something is wrong with my mouse, so I need to fix it. Okay, yes. Thank you. So you think that is a no, right? Anyone else? Please. Anyone else? Did you agree? If you agree, say, oh no, I bought the ticket because of the first diagram that you gave me, but why now you show me another diagram? And then the seat is not what I expected based on the first one. Right, so what Châu Long said was correct, right? Because the document, all right, is actually an evidence of prior negotiations or agreement that contradict or vary the contract terms, right? Because this is different from the contract's term because she already signed the ticket plus the different diagram, right? And it with the document saying that this is an entire agreement of the parties. So therefore, right? Therefore, applying the parallel evidence rule, right? Gary cannot introduce the evidence, right? Which is part of any prior negotiation. Okay, good. Let's see. So let me share the screen again. Sorry, 1 second. Right. So we know the parallel evidence rules, right? So what is the exceptions? What are the exceptions of the parallel evidence rule? Okay. So because of the rigidity of the parole evidence rule, the courts have created some exceptions, right? So the first one is that if the contract, right, subsequently modified, right, or like an evidence of any subsequent modification of a contract can be introduced in court, right? Or any voidable or void contracts. An oral evidence can be introduced in all cases to show that the contract was voidable or void, right? Like for example, introduced by mistake, fraud, or misrepresentation, right? Or if the contract is incomplete, like it lacks one or more of the essential terms, then the courts allow additional evidence to actually fill in the gap, right? Or any prior dealing, course of performance, or usage of trade, right, can be introduced as an evidence to explain or supplement a written contract, right? Or if the contract actually subject to an oral agreed on condition precedent. And the last one is that the contracts with an obvious or gross clerical error that clearly would not represent the agreement of the party, right? So those are the situations, the how can I say, the exceptions to the parole evidence rule. Okay, let's look at this one. Let's look at the example to clarify some points of the exceptions, right? So let's say let's look at some example. So if like how can I say, Danny agrees to lease an office space from real estate enterprises, right, for 3,000 US dollar per month, right? And they signed a lease provides for monthly payment of 300, right, rather than the 3,000 agreed to by the party. So in this case, can the parole evidence be admitted to correct the mistake? Are you clear? So Danny agrees to lease the office space from real estate enterprises for 3,000 US dollar per month. And the signed written lease provides for a monthly payment of 300 rather than 3,000 agreed to by the parties, right? And because the error is so obvious, can, right? Of course, it's obvious 3,000 and 300, right? Can real estate enterprises allowed to admit parole evidence to correct this mistake? The answer is on the slide. So we are at, so if you forgot, then I can show you the slide again. Right? So do you think that real estate enterprises can use parallel evidence rule in this case? This is very basic, guys. Yes or no? It's on the slide. I just give you an example to illustrate that, to make sure that you understand the concept. Anybody?
I guess we can apply the last one.
You can.
Because
Mhm.
303,000 is kind of obvious clerical error.
Okay. Yep. Right. Thanks, Lam. So because of the error is so obvious, like it's a typo error, so real estate enterprise would be allowed to admit parallel evidence to correct the mistake. Right. So usually anything that before the written documents are not, or contradicts or varies to the written document is not should not be allowed, right, in court. However, in this case, this is just an obvious clerical error. Therefore, the aggrieved party actually be allowed to admit the parallel evidence to correct the mistake. Okay. And this is the form of the contract. You can read more in Article 119 of the Civil Code. Okay, so before we move to chapter 4, let's have a break. Right, let's have 15 minutes break. We will back at 2:30. Okay, 15 minutes break.